Hello everybody, my name is Martyn and welcome to my presentation on damages and defences. In particular, today we'll be looking at CETA's case. So what specifically we'll be looking at today? So first we'll start by having a quick run through of the facts of the case. Then we'll discuss the issues that are relevant to this case. We'll look through the relevant areas of law, and then we'll apply the facts of the case to that law, and finally we'll draw our conclusions. So the facts. Whilst on holiday, Sita decided to go on a scuba diving course. After initial training, she was ready for her first dive. She had a couple of drinks because she was a bit nervous, and she knows that usually she can handle a couple of drinks with no impairment to her, but the barman serves her doubles. During her dive, her oxygen runs out. She panics and surfaces too quickly. The speed of her ascent causes damage to her lungs and brain. So the dive operator admits liability as the instructor failed to check the tank, which was 3/4 empty. But, however, they claim it was partially Sita's fault, as it was part of the training that she shouldn't surface too quickly. As a result of the accident, Sita can no longer work in her profession as an accountant. She loses her opportunity to play hockey for the state and get paid for it, and she suffers constant discomfort from her reduced lung function. So what are the issues we're actually discussing? Firstly, we need to establish whether Sita can actually claim damages for the losses she suffered, being her loss of earnings, her loss of opportunity for playing for the hockey team, and her pain and suffering as a result of her injuries. And secondly, if those damages can be claimed, are they likely to be reduced based on contributory negligence? So now the law, and firstly we'll tackle damages. So the general aim of damages is to put a person in the position they would have been but for the tort or but for the act of negligence. The main form of damages, therefore, are compensatory damages. There are other forms, including exemplary, aggravated, nominal, and contemptuous, but we won't go into too much detail about those. So when assessing damages, we need to take into consideration what's called the once and for all rule, which means they can only be awarded once for the same cause of action. The effect being courts will consider any future losses arising from that damage when assessing damages. Fitter v. Veal is an old case that illustrates that point. Next, we need to consider the eggshell skull rule, which means that a defendant must take a plaintiff as they find them. So long as the type of harm was foreseeable, the extent of that harm doesn't need to be. In Kavanagh v. Akhtar, a lady suffered an injury which meant she could no longer look after her long hair due to religious reasons, and amongst other things that led down to the breakdown of her marriage, and she suffered depression as a result. The defendant argued that wasn't foreseeable. However, the court held that suffering depression as a result of an injury is foreseeable, and therefore the extent of it isn't relevant. So the lump sum rule means that unless there's legislation around it, damages cannot be paid periodically or as an annuity. They have to be paid as a lump sum. So as an extension of the nature of damages being compensatory, the indemnity principle means that any future losses are likely taken into consideration when an amount of damages is awarded. The award is net of any future losses that that person was likely to suffer. Plaintiffs have a duty to mitigate any losses they suffer as a result of a negligent act or omission. A failure to do so will mean that their damages will be reduced. In Boyd v State Government, a Jehovah's Witness refused a blood transfusion, which in turn meant the court found they had failed in their duty to mitigate, and the damages they were awarded as part of that negligence action were accordingly reduced. The case of CSR v Eddy is a good illustration of the three types of compensable loss as part of a negligence action. Special damages include amounts already paid or lost by the plaintiff at the point of the case, including medical bills or lost earnings. Pecuniary general damages are monetary losses that they will suffer in the future, such as loss of earnings, future medical bills, etc., loss of opportunity to earn. And then general damages, non-pecuniary, non-monetary losses such as pain and suffering and distress that the plaintiff might suffer as a result of um, the negligent act. So loss of earnings capacity is compensable and it can be distinguished from a loss of earnings. This was illustrated in Medellin, where the court explained that a loss of earnings is basically a comparison of before and after the negligent act, whereas a loss of earnings capacity takes into consideration the potential that person had to earn in the future. So loss for pain and suffering is also compensable. In fact, in more extreme circumstances, higher awards of damages can be given. Um, the court will also consider mental illness and distress as a result of injuries. Freudhofer v. Polidano attracted a higher award of damages because the plaintiff was dragged underneath the defendant's vehicle. Loss of opportunity is also compensable. However, it will be apportioned based on the likelihood of that opportunity actually occurring. In Glenmont Investment, the court awarded damages based on the destruction of an animatronic dinosaur that had the potential or opportunity in the future to appear in movies. That in itself would attract a high level of damages, but the likelihood of that dinosaur appearing in movies was quite low, and therefore the damages were apportioned accordingly. So finally, in the principles applying to damages, we have the Limitation Act, which means that generally negligence actions will have a 6-year limitation period. Actions in negligence for personal injury will have a 3-year limitation period from the signs of the injury occurring, the effect of which, if you bring an action outside of that time frame, you can't be awarded damages for it. So here's a decision tree or flowchart that summarize the steps in determining whether damages will be awarded, and if they are, whether those damages will be reduced. So next we move on to the relevant law to the second issue at hand, and that is of contributory negligence. So contributing negligence is where plaintiffs have exposed themselves to risks that might reasonably have been foreseen and therefore avoided, to the extent they're found to have contributed to the harm that they suffered. The effect of finding contributory negligence is apportioning of the fault and therefore relative reduction in the damages, and that's in the Law Reform Contributory Negligence and Tortfeasors Contribution Act. When claiming contributory negligence as a defence, the onus is usually on the defendant to prove that the plaintiff was contributorily negligent. In order to do that, the defendant must prove that the plaintiff was at fault and the fault was a cause of the harm that they actually suffered, or causation. Section 5K of the Civil Liability Act states that when assessing whether a plaintiff is at fault for the purposes of contributory negligence, the assessment is the same as determining fault in the defendant if they were negligent. Those being, was care taken by the plaintiff the standard of a reasonable person in their position, and should they ought to have reasonably known at the time that their actions would cause harm to themselves. So in establishing whether the care taken by the plaintiff was the standard of a reasonable person in their position, courts will not take into consideration that they were intoxicated. Jocelyn v. Berriman states that they will be treated the same as if they were sober. However, if the situation was an emergency, then actions that are usually not deemed reasonable may actually be deemed reasonable in those circumstances. The second step in establishing contributory negligence is causation. When considering it, it's not necessary that the actions of the plaintiff actually cause the act or omission that caused them harm to occur, only that their actions contributed to that harm. Causation can be found in 3 ways. Either the plaintiff's own carelessness actually caused the accident. In Griffiths v. Doolan, a child ran out into the road and was deemed that their contributory negligence actually caused the accident to happen. Or actions increased their risk of harm, and as a party, the plaintiff failed to hold a handle on a train and there was an accident and they suffered damage and they were deemed to have contributed to increasing the risk of that harm, or their actions actually aggravated the damage, as in Eagles v. Orth. So finally, the Civil Liability Act, Section 5L, actually states if a client was intoxicated, then there's an automatic assumption of contributory negligence. This has the effect of shifting the burden of proof from the defendant to the plaintiff. They therefore need to prove their actions did not contribute to the harm that they suffered. This assumption can be rebutted if they can prove that the intoxication did not contribute to the harm, or that the intoxication was not self-induced. Again, here's a flowchart that summarizes the steps involved in determining contributory negligence. The first step revolving around whether the defendant can prove that the plaintiff was contributory negligent, and if they can't, whether the plaintiff was intoxicated, and therefore whether they can prove that they weren't. So next we're going to move on to step 3 and apply the facts of Sita's case to the relevant areas of law. Firstly, we'll tackle damages. So the first decision point is liability for loss proven, and we know that it is because the dive operator has actually admitted liability. So we can move on. Have damages already been awarded? There's no evidence that there is, and therefore that condition is satisfied. Next are the types of loss that Sita suffered compensable. We know that yes, pain and suffering is a compensable form of general damages. Loss of earnings is a compensable form of special damages and general damages, pecuniary, and loss of opportunity is a compensable form of general damages. So because she has compensable losses, we can then move on to checking whether the limitation period has been exceeded. There's no indication that there is in this case, and therefore we can move on. Damages will be awarded to Sita for the loss she suffered. So next we need to consider whether she failed to mitigate any losses. There's no evidence that she did, and therefore at this stage her damages won't be reduced. So next we'll apply the facts of Sita's case to contributory negligence, the second issue. Was the standard of care that of a reasonable person? Potentially not. So the next stage of the process is, should a reasonable person ought to have known that it would cause harm? And because the training involved the fact that coming up too quickly would potentially cause harm, then yes, that has potentially been satisfied. Now we'll consider whether there was actually an emergency. Well, it's likely that there is. She was panicking, she was running out of oxygen, and therefore there was an emergency. Because of that, it's likely that no fault at this stage can be proven, and therefore at this stage contributory negligence is not. However, the next stage is to check, well, was Sita intoxicated? Yes, she was. We know that from the high levels of alcohol in her blood. Now we consider whether the intoxication was voluntary. And in this case, it will be. There was a case of Russell v. Edwards where the plaintiff claimed that they weren't contributory negligent because they weren't aware of how much they would need to drink to become drunk. However, the court found that's still voluntary and therefore it's still self-induced. And in this case, even though Sita didn't realise that those drinks were doubles, then she was actually voluntarily consuming that alcohol, and therefore the intoxication would generally be considered self-induced. So because it was self-induced, we need to consider whether she can prove that that intoxication did not cause her harm. I find it unlikely that she would be able to prove that, considering that her judgment was likely impaired at that, which may have caused her to panic more and rise to the surface more quickly, causing the damage. Because of this, it's likely that Sita will be found to be contributory negligent, and her damages will be reduced based on that. So now we move on to step 4, and in conclusion, with regards to the first issue, it is likely that Sita can claim damages for her loss of earnings for being an accountant, a loss of opportunity of playing for the state hockey team, that may be reduced based on the likelihood of her getting on the team, and her pain and suffering as a result of her injuries. Secondly, it is likely that her damages will be reduced based on contributory negligence. She's unlikely to be able to prove that her intoxication did not impede her judgment and therefore was a cause of her harm. So just to summarise today, we talked through the facts of CETA's case, the issues arising from it, the relevant areas of law. We then applied the facts of the case to those areas of law and drew conclusions about the issues. Thanks for your time today.